Welcome back, everyone. Con law questionnaire was super tough. We're gonna go over the real property questionnaire. It'll be interactive, but we already have it filled out in the nature of time. So let's talk about real property. What's the definition of a present estate, and what are the different types of present estates? So there's a freehold estate, like there's a fee simple, and then a leasehold estate, which is like a tenancy. There's a life estate, a license, and a profit. These are different types of estates. But typically we have the fee simple, which is absolute ownership, and then maybe a lease, which is like temporary ownership, or a life estate, which is ownership measured by a life. A license is like, a privilege to use, and then a profit would be a privilege to take from the land. What does it mean for fee estate to be absolute and to be defeasible? So absolute means it cannot be taken away, whereas defeasible means it can be taken away. So a fee simple absolute means you have ownership of the property. A defeasible fee means that some event could strip you of your ownership of the property. A life estate. So a life estate, duties and obligations, an estate that exists for measuring life. So a life estate has the duty to maintain the premises, not to commit waste, repairs, pay taxes, and insurances. So it's a difficult question between who pays the taxes, the remainder man or the life estate tenant. The life estate tenant pays the taxes, and the life estate tenant pays the interest on the mortgage. The remainder man pays the principal. Why? Because the remainder man is the one who's going to inherit the property. The life estate tenant is the one who's getting the benefit of living on the property. So they'll pay the active expenses, the interest and the taxes, whereas the mortgage principal will be paid by the remainder man. The only time the life estate tenant doesn't have an obligation to pay interest or taxes is if the property is totally vacant and useless and unviable, like it's a desolate, unusable property, so that they're not gonna have to pay if they're burdened by the
It's an
ownership of it.
exception to that.
It's an exception, yeah. Can you have a life estate tenant on the base of a different person's life? Yes, absolutely. That's called a life estate or autre vie, right? Like a different life. What's the language for fee simple subject to condition subsequent? For fee simple, subject to executory limitation. So condition subsequent would be
Until an
like,
event occurs.
right, if Tommy marries Susie, then to
Conditional.
Johnny. So it's an event. Whereas a fee simple determinable is an automatic reversion, so
Duration.
long as until unless it's you, right? Like Tommy X is, well, Tommy to Johnny, so long as the property is not used to sell alcohol. Well, the minute Johnny turns it into a bar and sells alcohol, it's going to automatically revert back to Tommy. That's going to be a fee simple determinable. It has the automatic reversion, whereas fee simple subject to condition subsequent has that right of reentry. But if Tommy gets married, then Susie retains the right to take back the property. So that's the difference between fee simple determinable, automatic reversion, and fee simple subject to condition subsequent, which is a right of reentry.
So this shifting is one of the things that throws me off a little bit, the shifting.
Yeah, we'll get to that right now. So subject to executory limitation. When you see executory interest in real property, you're thinking a third party, someone who's going to take after, like potentially a third party who could take after a stated event. So a shifting versus springing executory interest. Shifting goes from grantee to a third party. So A to B, but if B, converts to a different religion, then to C. That would be a shifting executory interest that C has, because it could shift from B, the grantee, to C. Whereas a springing would be to B if B gets married. So it's just going to go from the owner to B. It's going to spring from the grantor to a third party. Shifting will go from a grantee to a third party. Springing will go from the grantor to a third party. So springing just means it
From
divests.
Tommy to Susie, right? It will go to Tommy and then Susie.
Yeah. So
Right.
springing just means Tommy owns a property and has a clause on it that if Susie gets married, the property springs to Susie, right? That's springing. Shifting means Tommy sell or conveys the property to Susie, and if Susie gets married, then it shifts to Johnny. Johnny has a shifting executory interest from a grantee.
Okay. Thank you.
A future estate is an interest in property that may vest in the future, right? Like a remainder man, let's say. There's
Yeah.
a contingent remainder or a vested remainder. A contingent remainder means that it's not certain, like only a event could occur, but if it doesn't, the remainder man might not get it. Where a vested remainder means it's certain to go to that person. Now, vested remainders could be indefeasibly vested, which means not only is it certain to go to that person after, let's say, the life estate or whatever, but it'll remain with them. Whereas a vested remainder subject to total divestment or vested remainder subject to open means that they could actually end up being stripped of that, or their stake could be diluted because the class continue to grow. That's what subject to open means, that the class can grow bigger. Subject to total divestment means it goes to you, but then it could be taken from you if an event occurs. These are going to be subject to the rule against perpetuity for sure. What's the different types of class gifts in the future state context? Like to all the nieces and nephews or the graduating class of 2012. These are class gifts. So that could be subject to open because the class could grow if they have more nieces and nephews or there's a greater class. The rule against perpetuities. No interest in land is valid unless it must vest, if at all, within 21 years of the death of a life in being at the time the interest was created, or actually vest within, 360 years in federal law, 1,000 years in Florida. Rule against perpetuities means that we're not going to allow property to just remain in limbo. If there's going to be property that to Tommy, but if Tommy has a kid, if one of Tommy's kids becomes president of the United States, then to Johnny. Well, that could be problematic, like to Tommy, but then if one of Tommy's kids becomes president of the United States, to Johnny. Well, isn't it possible that like it'll go to Tommy, Tommy dies, and then Tommy has kids left, but we're not sure if more than 21 years are going to pass before one of Tommy's kids becomes president or not, and then that would transfer it over to Johnny. So it's like that could implicate the rule against perpetuities. I'm not going to get too deep into that because of time right now, but just know that that's what the rule against perpetuities really implicates. When there's an opportunity for land to not necessarily vest over 21 years of the death of a life in being, the measuring life. So the measuring life would be like the youngest person. Is it possible that, okay, in that situation, Johnny, or the youngest son could die, and then more than 21 years after that person's death, a brother could become president, like a brother who wasn't born yet could become president, and then it would cause divestment. That would maybe implicate rule against perpetuities. The more classic example is this one, the fertile octogenarian. So grandma gives property and has a clause that says to any of my sons who reach the age of 30, and she only has one son who's 31. Well, that clause could violate the rule against perpetuities because it's true that she could have a baby the next year, then she could die, then the 31-year-old kid could die, and then it's not sure whether or not that baby will reach the age of 30 within 21 years. So it's kind of like, fertile octogenarian could be a rule against perpetuities problem. This is a lot. Don't get lost in it. It's just good to hear. All right, let's get back into stuff that's more heavily tested. Different types of waste. So there's voluntary, like you kick a hole in the wall, permissive waste, like you let it rot, or ameliorative waste, you improve the property but are still liable for costs. So waste applies to landlord-tenant, whether the tenant commits waste, or waste can also apply to a life estate holder, someone who has, a property, but it's going to not be theirs after their death. They have the duty not to commit waste. Landlord-tenant, this comes up, a good easy essay, I think. You could have a tenancy for years, which is a specific period of time. A periodic tenancy, which would be like a month to month or a week to week, or one full period in advance for only 6 months for year to year. That's how much notice is needed for ending the terms. But periodic tenancy is for a specific period, whereas periodic tenancy is for like a repeating time, like month to month or week to week, where tenancy for years is for a specified time period. A tenancy for years doesn't have to be for years. It could be like a 6-month contract. And then tenancy at will, and then tenancy at sufferance. Tenancy at will could end at either time by either party, and a tenancy at sufferance is like a holdover tenant, someone who's staying longer than they're supposed to. The mnemonic we remember is your period will suffer, right? Tenancy for years, periodic tenancy, tenancy at will, tenancy at sufferance. I'm not sure. I'm sure that actually is true. I've had girlfriends before and seems to be the truth. What are the rights and duties of a landlord? So the landlord has to collect rent, duty of habitability, quiet enjoyment, and duty of repairs, right? These are landlord duties. Habitability and quiet enjoyment are the big ones. Habitability is to like maintain a premises that is livable, and then quiet enjoyment means that there's no intrusion from outside, let's say neighbors, or the landlord is not intruding upon their living situation. What are the rights and duties of a tenant? So the tenant has to pay rent, not commit waste, some duty of repair, and then this would actually be the duty of the landlord, is the duty to deliver actual or legal possession. So what that means is, like, in most jurisdictions, you have to deliver, the legal possession, they have the right to live there, and the actual possession, mean there's no holdover tenants. In the minority of jurisdictions, you don't have to deliver the actual possession, and they're not responsible if there's a holdover tenant. That could be a tough MBE question, but not really going to come up probably on the MBE. So, what is a constructive eviction? When the duties of habitability or quiet enjoyment or repair have rendered the premises unsuitable for occupancy and the tenant needs to move out. So if they actually have to move out, they've been constructively evicted. What's the default form of tenancy agreement? Would be tenancy in common. So we have to understand tenancy in common, joint tenant with right of survivorship, and tenancy by the entirety. Tenancy in common is what we assume, and a tenancy in common means that if one tenant were to die, then their share of the premises would pass to their heirs or descendants. There's no survivorship, meaning that the other party doesn't survive them and take their stake. For JTROS, a joint tenancy with the right of survivorship, that is what happens, where if one party dies, the other party takes and gets that, the entirety of the property. In order for there to be a JTROS, we do need these 4 elements: T-tip or PIT, time, title, interest, and possession. So the 4 unities, these all have to occur at the same time. So if Tommy and Johnny create a JTROS in a property and Tommy gets 60% and Johnny gets 40%, that's not a JTROS because there's no unity of interest, right? They have 60 and 40%. They need to take 50-50. The 3 types of joint tenancies, like we said: tenancy in common, tenancy of right of survivorship, tenancy by entirety. And a tenancy by entirety is simply a JTROS, time, title, interest, and possession, plus marriage. Right? That's a tenancy by the entirety. Some states require a straw man, which is a third party that you'll convey the property to, and then they'll convey it back to the married couple so that they can satisfy that, unity of time. But a lot of jurisdictions have eliminated the need for a straw man, and you can form a tenancy by entirety simply through the act of marriage. If you haven't answered for the above questions, how do these types of tenancies affect co-tenants' rights to rents, repairs, and improvements? So the right to inhabit the whole and to receive contributions. So that's what that means. Like when you have a tenancy in common, it's not that you have the right to 50% of the property. You have an equal right to inhabit the entire property. So they can't really partition you off, or they can't perform what's known as an ouster by renting it out and not letting you live there. You do have the right to live there in its entirety. What's the difference between a sublease and an assignment? So a sublease is like part of it, whereas an assignment is the remainder of it. So if you have a year lease and you sublease the summer months 3 to 6, that's a sublease, and only the original parties could be held liable. If you have a year lease and you assign months 9 to 12, the final 3 months, that's an assignment. That's the remainder of the agreement. And therefore, if there's a breach, the original party, the sublessor, and the new party, the sublessee, or let's say the assignor and the assignee, could all be liable. So in an assignment, all three parties can be held liable. In a sublease, only the original parties can be held liable, not the new sublessee. What are the landlord's options if the tenant surrenders the lease early? They can relet the property and seek damages, and the majority rule is they have to mitigate. They have to try to relet the property. What's the implied warranty of habitability and the implied warranty of quiet enjoyment? So habitability means it's fit for human dwelling, and quiet enjoyment means free from interference. Those are good definitions. What's the difference between lien theory and title theory? So lien theory, a mortgage will sever JTRS under title theory, but not a lien theory. So if there's two parties, A and B takes out a loan on the house, in a title theory state, that would sever the JTROS and turn it into a tenancy in common. In a lien theory state, that wouldn't. That just operates as a lien on the property, and it doesn't it doesn't abolish the JTROS. And if the party were to die under a lien theory state, then the creditor could not collect from the other party, right? In a lien theory state, it doesn't attach to the other party. It just is personal to the lender or to the borrower. In a title theory state, it they have title to the property and they could go after the other party, and it's not personal, it's title to the property, right? So lien theory state severs the JTROS, title theory state doesn't sever the JTRS when there's a mortgage or an encumbrance on the property. How can a joint tenancy be severed and what happens? So agreement, death, divorce, partition, or murder, right? And when a joint tenancy is severed, it just follows the agreement. It would probably be split up. It could be a sale, like a forced sale of the property, or it could be a physical partition where they just split it up. What do courts prefer, partitions or forced sale, and how they decide? They probably prefer the forced sale. It's a lot easier. Physical division of the property is pretty tough. So covenants and servitudes. Real covenants versus equitable servitudes. What's the difference? It doesn't matter. So real covenants for money damages, equitable servitudes for equitable relief. These are like when I live in a townhouse association, we all have to paint our doors blue, or like Santorini, Greece or something. That is an equitable servitude, right? Because it's equitable, like it's an enforcement. If I paint it red, they're gonna be like, yo, Andrew, you gotta paint it back blue, right? A real covenant would be money damage. If you park in someone else's parking spot, you have to pay $100 per day. That would be a real covenant. What does it mean for a covenant to run with the land? Like the next possessor can enforce it. What's the difference between horizontal and vertical privity? Horizontal privity is between the original buyer and seller. Vertical privity is between subsequent parties. When will courts imply restrictive covenants for schemes or plans of a subdivision? When there's notice and intent. So common scheme or plan, they could, notify if there's notice, it was in the records and it was intentional to apply to all the properties, then it could apply. For a real covenant or equitable servitude to run with the land, there needs to be notice, intent, it needs to touch and concern the land, and it's questionable whether there needs to be privity or not. It's usually should be in writing and there should be privity, but these elements have kind of been relaxed. I don't anticipate them really getting into the details on an essay question for that. What are the duties and obligations of individuals who live in condos, co-ops, or other HOAs to maintain common areas under reasonable standards? Fair enough. What are 3 different types of notice jurisdictions and why do the differences matter? So there's pure notice, race, and race notice. Pure notice, the fact pattern would say like, anyone with notice can, if someone has notice, then they cannot prevail, right? So pure notice means subsequent bona fide purchasers will prevail. So people who take in good faith without notice, anyone takes without notice will prevail is a pure notice jurisdiction, meaning it doesn't matter if they record it or not. It just matters if they were a bona fide purchaser. A bona fide purchaser means they take for value without notice and in good faith. And there's different types of notice. There's actual notice, like they literally knew that someone had an interest in the property, like they were aware of it. There's inquiry notice, which means like a reasonable inspection of the property would have put them on notice. And then there's record notice, which means like it was in the recording and they should have known. So if you have notice, you won't prevail under a pure notice jurisdiction. But as long as you don't have notice, you will prevail. Under a race jurisdiction, it's just whoever records first. So if it says first to record, it's going to be a race jurisdiction. If it says whoever takes without notice and first to record, that's a race notice jurisdiction. And that means that, you have to be the first bona fide purchaser to record. So these concepts can be pretty tough. We'll work on it. Tomorrow, y'all are coming to my MBE class, hopefully, or next week we'll do some, real property MBE questions. It'll help you on that, but that's the concept of notice jurisdiction. Notice we talked about can be actual constructive. Constructive is like inquiry or record notice. The shelter rule means that people can take downstream shelter in bona fide purchaser status, meaning that like if Tommy is a bona fide purchaser and then Tommy gifts the property to Johnny, Johnny can also claim a bona fide purchaser, meaning that like they take shelter in the upstream status of the prior holder. We'll see the shelter rule come with holder in due course too in well, I don't think we do commercial paper here, but it's a concept, meaning you can take shelter in an upstream holder. Like usually if you have to take for value to be a bona fide purchaser. So if you're gifted a house, you're not a bona fide purchaser. But if a bona fide purchaser gifts you a house, then you can take shelter in their status. What's required for the benefit of a covenant to be enforceable? Touch and concern the land, intent, notice, and privity. And then for the burden of a covenant to be enforceable, touch and concern the land, intent, notice, and then less privity. This has been changing. So I don't really need to think you need to be super concerned with this. Just know that it has to touch and concern the land. What that means is like they're, having a blue door that touches and concern the land, having to vote for, the Republican or Democratic candidate would not touch and concern the land. They can't enforce that on the property, right? All right, I know we're moving quickly, but I just want to get through this questionnaire and we'll go back over everything and just, one stone at a time, but it's good to hear this stuff. What are the different types of easements? So we have express, implied, easement and gross, easement of pertinent, easement by prescription, easement by necessity, and negative easements. So express is in writing, implied is by conduct, easement and gross is personal. It's not tied to the land. It's, with the utility company, let's say. Easement of pertinent, right? It takes two. There's a dominant and servient estate. It runs with the land. Easement by prescription, hostile, open, continuous, adverse, and notorious. So this is like, the statutory period where, you've walked across this path for this many years without anyone complaining. So now you're allowed to continue doing it. Easement by necessity, when you need access to a public road, you're so hemmed in that you can't access a public road. And then negative easements, like a restrictive covenant, like land or like air or light or water, you're restricted from doing something. So easements are like rights of there are many different ways an easement can be terminated, like merger, express easement when the necessity ends, and abandonment. We'll see merger, like if one person buys the two properties and merges them together, and any easement that existed between them no longer exists because now they're not two separate properties. Adverse possession is similar to easement by prescription, but it also has to be exclusive. So the mnemonic I use is ocean, open, continuous, exclusive, adverse, notorious, and for the statutory period. This means like you're a squatter. These are squatters' rights. This is someone who, you're living on a property for a long enough time out in the open, and eventually you just retain title to it. And then tacking means you can add on years from a previous possessor. So if Tommy squatted for 7 years and then Johnny comes in and squats for 7 more, Johnny can say that he has 14 years of continuous adverse possession to potentially meet the statutory elements. So the adverse possessor does gain title. Adverse possession requires exclusivity. Prescriptive easement does not, right? Multiple people can have the same right of use to cross over a property. They can walk across the same bridge, but only one party can have title to the property. A license is different from the covenant easement because it's permission to be on the land, like a ticket to a sporting event, whereas, an easement is not revocable, whereas a license is freely revocable. And then a profit or prendre, a profit is the right to take minerals from the land, or the right to extract from the land. Okay, mortgages can be tough. So what do we want to learn about mortgages? A mortgage is a loan secured by real property. The mortgagor is the person who takes out the loan, and the mortgagee, usually the bank, retains a security interest on the property. So a loan secured by real property is the mortgage. The mortgagor is like the homeowner. The mortgagee is like the bank. A purchase money mortgage is when the money borrowed is used to buy the property and they get super priority. So purchase money mortgage, a PMM, is if the bank lends Tommy money and Tommy uses that money to buy the property. Well, now the bank gets the highest priority in the case of a foreclosure. And what is a foreclosure? A foreclosure is when the mortgagee initiates a forced sale of the property to pay off the outstanding mortgage. There may be junior mortgagees, and a foreclosure will terminate their interest in the property, and they will need to seek a deficiency judgment against the mortgagor for any deficiencies. The mortgagor may have an equitable right of redemption to buy the property before the sale, or a statutory right of redemption to buy the property after the sale. So the foreclosure is the forced sale of the property. And then priority, like who gets paid off the forced sale, the PMM, the purchase money mortgages first, then the senior mortgagee will have the, next priority. And there's no PMM, they'll have the top priority. And then the junior mortgagee will have junior priority. They will need to collect via deficiency judgment. A deficiency judgment is when the sale is not enough to pay off the lenders, and you're going to need to collect from the homeowner personally. So a deed of trust is pretty much a mortgage. There's no real difference between a mortgage and a deed of trust. It's just the way it's recorded. An equitable right of redemption would be before the sale, and a statutory right of redemption is after the sale, meaning like if the bank forecloses on the property and they're going to have the sale in 30 days, but you come up with the money in 15 days, you can exercise your equitable right of redemption. Like, hey, I got the money, don't sell the house. Some jurisdictions even allow a statutory right of redemption where they sold the house and 15 days later you come up with the money, you can still buy it back as a matter of right. What's the significance of any of the mortgage note itself? So a mortgage consists of two documents, the note and the security agreement. So the note is the loan, right? Like the IOU, the promissory note, and the security agreement is the collateral agreement that attaches the land to the loan. So it's really two documents stapled on top of each other, a promise to pay and a collateral agreement, which identifies the property as collateral. In the case that there is a default, then they can have a foreclosure. A mechanic's lien, when a mechanic isn't paid and gets lien on the property, similar to construction lien, right? A lien is like someone works on the property, they don't get paid. Now they can, record a lien on the property and then foreclose that lien. And then exactly, they'd have to sell the property to pay them off. What are the rules for future advanced mortgages? Allows you to access more money in the future off the same property. Sure, that's legal. What's the difference between assuming a mortgage and taking possession of property subject to? So expressly assume means like A has a mortgage and then B expressly assumes it. So now B is going to become primarily liable and A is going to remain secondarily liable. Now, what if A has a property and B takes subject to the mortgage? Well, now A remains primarily liable and B becomes secondarily liable. The only way for A to get off the hook completely is to execute a novation, which is a true substitution of the parties. So expressly assume means that the new party becomes primarily liable and the second party becomes secondary liable as a surety, and subject to means that the new party becomes secondary liable as a surety and the original party remains primarily personally liable. Sale contracts and title. So, contracts for the sale of land do need to be in writing. Remember my legs, the L is for land, but not if it's a lease under 1 year. Do land sale contracts need to be written up by lawyers? No, anyone can write them. What are the different types of real estate listing agreements? Right to sell, right to list, and exclusive versus non-exclusive. So right to sell means that, if the property sells, you're going to get paid. You're the agent. Right to list means you're only going to get paid commission if your listing sells. Other people could have that right to list. You just have the right to list. And then exclusive versus non-exclusive, exactly. It means like, are you the only one or are other people allowed to do it? If you're a real estate agent, you want the exclusive right to sell. What is a deed and what's the merger doctrine? So a deed is a written declaration of title, and the contract will merge with the deed, meaning once the deed's been recorded, you can't sue on the contract anymore. You're going to have to sue under the deed. We see this concept of merger come up twice now. Merger, how you merge two properties and extinguish an easement, or merger, how a contract can merge with the deed and there will be no contract claims remaining. So when is a deed delivered? When it has left the control of delivery. So, it's like if Tommy gives Johnny a deed and says, hey, I want you to record this in 5 years, but if I ask for it back, give it to me before then. That's not delivery because it hasn't left their control. If they say, hey, record this in 5 years and I can never take it back, that is delivery. Different types of deeds. I tell people, you come to me on the day of my daughter's wedding and you ask, am I ready to pass the bar? This is one of my favorite questions to ask people. What are the 6 warranties of a general warranty deed? I think it's a very specific question that kind of just is like that level of mastery. If you're like, do I need to know that? I'm like, I mean, you need to know a lot of stuff, and that's one of the things that I would say is kind of like a yes. And if you don't know it, it kind of indicates you don't know a lot of similarly difficult things. So I feel like that's the level of competency you need to know. Like you should know the 6 warranties of a general warranty deed. The present warranties are the right to convey, the right against encumbrances, and the right to sizen. Right to convey means you can sell the property. Right against encumbrances means there's no mortgages, liens, litigation on the property, and the right to sizen means you are the true owner of the property. General warranties for the assurances and quiet enjoyment, these are future warranties, so they'll come after the deed has been delivered. Quiet enjoyment it means that there's no one else who has a claim to title. A special warranty deed only warrants for the time the seller had title, so it doesn't warrant for upstream defects in title. And then quit claim deed, there's no warranties. It's just kind of like you take it as is. So what is title and why is it important? So legal ownership of property by deed, by adverse possession. So people get confused. What's the difference between title and deed? Title is a position of ownership. Deed is a written document that gives someone title, if that makes sense. You can have title by deed. You could also have title by adverse possession, let's say. What is chain of title and how does a wild deed play into this? So the history of who had title, that's chain of title, and a wild deed is a randomly unconnected deed. If Tommy pulls up and is like, hey, I have a deed, where'd you get that from? That's a wild deed. Estoppel by deed means that if someone conveys property that they didn't have the right to convey, but then later is granted that right to convey, they'll be estopped from denying the earlier conveyance. So A conveys land to B, but A does not own the land. Later, A inherits the land. A is estopped from denying the earlier conveyance, and B is titled to land. This one comes up a lot on the MBE, where it's like Susie, conveys the property to her boyfriend, but it's Susie's mom's property. Then Susie's mom dies and gives the property to Susie. Who owns the property? The answer is the boyfriend, because the earlier conveyance is activated. There'll be a stop from denying that earlier conveyance under the theory of estoppel by deed. That definitely comes up a lot in the MBE. What are the different types of title insurance and who has responsibility in purchase? So equitable conversion, the risk of loss transfers to the buyer after contract during the period of escrow. So I think there's like owner insurance or borrow insurance, like who buys it. But that's a important concept, is equitable conversion, meaning like during the period of escrow, after the contract is signed, but before the closing, the risk of loss transfers to the buyer. So they're the one who should have insurance. And it also means that if they die, their estate will be stopped from denying the transaction. They're going to have to go through with the transaction and buy the property. Same with the seller. They'll have to go through with the transaction under that theory of equitable conversion. They've become the equitable owner of the property. What's marketable title and what makes title unmarketable? So marketable title means that when you convey property, there's no encumbrances on it. And encumbrances could be like easements, liens, zoning restrictions, like pending litigation, if the property was acquired by adverse possession, if the property was acquired and has a right of first refusal, if the property has if it's the feasible fee, right? if it's subject to condition subsequent, things like that. Anything that just makes it like not ideal. Like think about it. If you buy a house, you don't want a house that like could be taken from you if Tommy marries Johnny or something. That would be unmarketable title. If you buy a house, you don't want a house that's like doesn't conform with the zoning laws, or a house that your neighbor has the right to walk over it. Like these would not be marketable title. Now you could still like agree to purchase a property that doesn't have a marketable title, but marketable title is implied in every land sale contract. Can a buyer still take possession of the home if the seller's unable to provide marketable title? Yeah, right. You can, but it would be dumb. But you can agree to it. What is the doctrine of equitable conversion? The risk of loss passes to the buyer upon the day of the contract, not the deed during the period of escrow, and the buyer becomes, the owner of the property. When is failure to provide title upon a specific time a material breach of the sales contract? Only if a time is of the essence is included. So if you have a contract closing to be in 30 days and 30 days later they're not ready, but 10 days after that they are ready, that's not going to be a material breach that leads to rescission. Unless they say time is of the essence, we need it because, we're hosting an inauguration party 2 days later. But if there's not a time is of the essence clause, then it's not going to be a material breach in a land sale contract. What's the implied warranty of good workmanship and who has it? Workers have to work good when building a house, like contractors. To which party, seller, buyer, do most states assign the risk of loss after signing the sales contract? We said the buyer under equitable conversion. All right, and finally, thank you all for bearing with me. Miscellaneous. What is the test to determine if personal property can be deemed a fixture? So you shake the house and whatever falls off the walls is a fixture. Things that are permanently attached. Like these would not be fixtures, right? These diplomas, not fixtures. The let's say the tiles on the floor, certainly fixtures. Or
Kitchen cabinets.
what'd you say?
Kitchen cabinets.
Yeah, the kitchen cabinets, those would definitely be fixtures. This, not a fixture, right? It's not a fix, so that's pretty obvious. Trade fixtures, are like, let's say Chipotle comes in and puts their kitchen cabinets in. Well, they can be removed so long as they restore the premises to its original condition. So yeah, like a trade fixture is like a kitchen oven or equipment. Riparian rights or water rights. So you cannot interfere with the reasonable use of water, interrupt the flow of water, right? That's usually the reasonable use or the reasonable flow theory for riparian rights, water rights. What are adjacent and lateral rights, and do you have a right to a view? So you have the rights not to have your house sink. You have the rights below your property to the center of the earth and above to a reasonable distance, like flying a kite. So yeah, like you can't really dig under someone else's property if it would cause your property to submerge. If you cause your neighbor's land to sink, and the only reason it sinks is the weight of the building, you're not liable. You're only liable if you cause your neighbor's property to sink and it would sink naturally. That's a tough question on the MBE. So it's like if A and B are next to each other and B digs under B's own property, but by B digging under B's own property, A's property sinks. Well, now the question is, did A's property sink because A had a building on it, or would A's property have sunk in its natural state? If it would have sunk in its natural state, then the neighbor's liable. If the only reason it would sink is because the weight of the building on it, then they're not liable. That's an MBE question, getting into the weeds, but that's pretty much that. You don't really have a right to a view. That's the Fontainebleau versus Eden Rock case. Like, if you want a view of the beach, you should buy the house that's like touching the water, right? Because it's okay for someone else to build another house right in front of you. What's a zoning ordinance and why do we have them? So rules about property to maintain a nice world. A variance is applying to do something differently than you're zoned for. So if I move into a residential neighborhood and I want to open up a barber shop and get a commercial zoning license, I would apply for a variance. Whereas a non-conforming use means you're grandfathered in. Let's say I owned a barber shop and then they rezone my neighborhood for residential. And they're like, you know what, since you already own the barber shop, you're grandfathered in, you'll be granted non-conforming use, right? You're grandfathered into using a different zoning law than before. And then an amortization is slowly stopping a non-conforming use over time. So if they're like, okay, you can have a barber shop, but first year you can have 10 barbers in your shop. 5 years later, you can only have 3 barbers in your shop. And after 10 years, you can have 0 barbers. You have to slowly stop doing the non-conforming use. That would be an amortization. What changes to a non-conforming use are allowed? It depends on the zoning laws. What's the Fair Housing Act? And it prohibits discrimination, right? What are the statutory exemptions to the Fair Housing Act? I think this means if the person lives in the house and there are less than, or there are four or less units, right? Like if it's a small property and there's like four or less and they live there, then they're exempt from the Fair Housing Act. Let me just confirm that real quick. Sorry. Yeah, buildings with four or fewer units where the owner lives in one of the units, right? That's gonna be exemption to the Fair Housing Act where they could be exempt. So, it's just like something to look out for. Sorry. All right, and then pretty much getting to the way end of things. What is redemption? The property no longer exists, right? It's been deemed. So like if you in a will say I'm gonna give, Blackacre to Tommy, but I sell Blackacre before I die, well then that gift has been deemed, it no longer exists. What hasn't been covered in this questionnaire you could think of that could be tested on MBE, UBE, or you have questions about? And someone might have said replevin, the right to recover stolen goods. Yeah, that's like a contract, property thing. Like if you were driving down the street and like, hold up, that's my bicycle. Like what? Someone stole that from me 2 years ago. You can't just really take it back. You'd have to go to the sheriff and get a writ of replevin and he'll go and recover it for you. I think when we do secure transactions, we'll look into that a little bit. But I mean, that's what we got for today. These are, I'm gonna put these in the classroom. So you'll see week 1 was contracts, towards week 2 is MPT, and then week 3 I'll add the real property and con law questionnaires and completed questionnaires. And then I'll add the assignments, which will be to write a con law and real property essay. And of course, we'll add the 2 recordings from tonight. And we'll just keep it moving. It's a fine thing to do. Like the UBE is so much more manageable than like Florida or California, let's say, because the subjects mirror the MBE. It's all federal law, nothing too difficult. So we've done contracts, torts, we did MPT. Today we did property and con law. We're going to do Civ Pro evidence, agency partnerships, corporations, LLCs. Then we'll do trust and wills. And then we'll do secure transactions and family law, then Crim Pro and Crim Law, and then we'll do an MPT MEE review. I definitely want to spend some time before class, at the beginning of class next time, looking at some property and con law essays and model answers, and then we'll go over the questionnaire. So I don't want to say we're behind schedule, but I like to revisit some of the topics, and I don't want to just do the questionnaires. I also want to go over some actual essays with y'all. So that's how we'll start class next week. But look out for the assigned essays, which I'll upload to the classroom probably tomorrow. But I really want to thank everyone for hanging out with me on this beautiful Saturday night. It's been a super pleasure. I'm gonna stop this recording.
Thank you.